Words to the wise, there is no reason and no way that a human mind can keep up with an artificial intelligence machine by 2035. Philosopher Gray Scott. But maybe that's the wrong concern. AI can most certainly outthink us. But the only way it can change our lives and replace us is when we let it make major decisions for us. And in our job market, it's starting to do just that. Look out for the warning signs. Currently, 88% of organizations are at the mercy of AI for at least one function. And this is the stat from around the entire world. 88%. The workforce is among the most impacted by this rise in AI. So what does this mean for workers? 83% plan to use it within the next year. Even if you do not feel the pressure of AI just yet, its influence is increasing. And with that increase in influence, we have to adapt with that as well. We need to learn about AI and the laws that govern it, and its characteristics, because whether we like it or not, we can't stop it. Who knows, maybe in the next job that you apply for, an AI will be deciding your fate. I'm Somi, and this is Legal Call to Sanity, where I will explain the ins and outs of legal policies and ethics, stripping away the fancy terms that hide the truth, to show you exactly what's going on in your country. In our first case, iTutor versus Equal Employment and Opportunities Commission, the EEOC, this is exactly what happens. 1. iTutor Group Incorporated. 2. Shanghai Ping'an Intelligence Education Technology Corporation. And 3. Tutor Group Limited. These three companies provided English tutoring services to students in China. Naturally, they started hiring in the United States. They get over thousands of applications, and they use only one preliminary screening process to see whether or not a tutor is suitable and can proceed with an interview, or whether they get an automatic rejection letter. iTutor Group did this with an artificial intelligence software. However, while this doesn't seem like an outreach of AI just yet, the case changes when that AI is used, intentionally or unintentionally, to be biased and unjust. The plaintiff of this case, a woman over the age of 55, applied as a tutor for iTutor Group under her actual birth date. Her application was almost instantly rejected by the company's automated AI software. However, when she applied using a younger birth date, she was given an interview. She hadn't changed anything besides her birthday, not her references, qualifications, or experience. It was exactly the same. Yet she received an interview after being initially rejected, just for changing her age. Imagine becoming older, having all the experience and credentials in the world. Credentials that took years to build up, by the way, and then simply being cast off for a job because of your age. At the same time, one could argue that age is a mark of wisdom, but in this case, any woman over the age of 55 and any man over the age of 60 was instantly unqualified to become a tutor. A plaintiff brought this case to the Equal Employment Opportunity Commission, which sued iTutor Group as well as the two companies they were working with under the 1967 Discrimination and Employment Act. This suit was filed as a class action because, like the plaintiff who brought her story to the EEOC, over 200 other certified applicants were rejected as tutors for iTutor Group just because of their age. So make no mistake, this was not a one-off thing. It was a pattern. The Age Discrimination and Employment Act, ADEA, that is being sued under has several statutes. But in regards to this case, the EEOC argued that iTutor's hiring practices violated Section 4 of the Act, which, while sounding fancy, just means companies can't reject fire, or discriminate against anyone just because of their age. The EEOC articulated that the artificial intelligence software is integrated at several levels and stages of the company. Within those agents, resume scanners, and other tools that they're using, if an application doesn't meet their predetermined criteria, including age, the agent can simply reject the application without the application ever having gone through a human's hand. If an AI can just reject someone without them having any say in it or having any chance to refuse it, are humans really the ones in control of the job market? Getting auto-rejected by an AI for a job you build credentials for just due to your age is saddening. Don't you think that the deafening impact of AI has already skyrocketed too far? Laws, well in this case, work to show the AI's violations, will undoubtedly fall behind if it is not refined and amended to fit the ever-evolving nature of computer science. The EEOC is one organization focused on ensuring that new uses of integrated AI, while allowing increased productivity, follow the code of law. Companies are free to use AI all they want, but they're also at risk for taking the fall of any discrimination or unlawful practices by their programming. In this case, the EEOC wished to get a court-issued injunction to end the discriminatory practices and get full compensation for damages. However, the result was a settlement of $365,000 from iTutor Group to over 200 workers who were rejected based off of their age. They were also given compensation and back pay and invited to reapply to the program. However, during and after this lawsuit, the corporation decided to forego hiring in America. As a safeguard, in case they did resume hiring in the United States, they would have to adhere to the following requirements. They were not allowed to ask an applicant's age during the screening process or before offering a job, and that requirement would stay in place for 5 years until after the date, or 3 years after the resumption of hiring in the United States, whichever one was later. And currently, that injunction is still in place. So, think about the job market right now. It's struggling, isn't it? People can't find jobs even though they have all the experience in the world. But really, are humans at the fault for this? Or are new AI agents the problem here? Think about it. Burroughs once stated, even when technology automates the discrimination, the employer is still responsible. iTutor Group used AI to make hiring decisions, but even if their AI discriminates against people, they still take the blame. But what happens when the AI isn't built by the employing company itself? Who's to blame then? The company that made the AI or the company that's using it? Well, that question brings us to our next case, Mobley v. Workday. Imagine applying to hundreds of jobs and getting rejected instantly. It's like having the door closed right in front of your face, and that is not a good feeling. Now imagine that the closed door isn't because of a person, it's because of an AI algorithm. We've discussed how companies can program AI to discriminate on job applications based on predetermined criteria. But what happens when the AI inevitably becomes biased and discriminates based on its data? Well, this is exactly what happened in the case of Mobley v. Workday. Workday is a human capital management platform, which basically handles HR processes, including hiring. Workday creates AI screening tools for over 10,000 US companies, including some large names like FedEx and Walmart. Walmart alone has over 1 million applicants a year. Workday AI has access to all of these applications for a scan to see if they are suitable. However, the AI's methods are not necessarily just. So, AI agent neutrality, while considered putative by some, is not necessarily true. After all, AI is programmed by humans, and humans can have bias, even if they don't intend to. In the case of Mobley v. Workday AI, the plaintiff, Derek Mobley, a black man over 40 with disabilities, was deliberately rejected from over 100 job applications that were all screened by Workday's AI agent. He sued them for discriminating against applicants because of race, disabilities, and age. Mobley wanted to have Workday AI held accountable for the employment discrimination and get an injunction or a court order for Workday to stop using its AI screening systems. And he wanted to get compensation for his lost job opportunities. He also wanted to turn the suit into a class action to represent any other people who were also victims of the AI bias. However, the defendants, Workday AI Incorporated, claimed that it was only a software provider and it offered quote-unquote employment recommendations. It wasn't the actual employment agency, so under the act cited, they wouldn't be sued. They also claimed that an AI agent unintentionally discriminating was not the same as intentional disenfranchisement of older applicants. In an even simpler sense, it's like a student blaming their calculator for getting a bad grade on a test. Even if the calculator was in fact faulty, it was the student using it. Hence, they would face the blame, not the company that made the calculator. Since Workday AI was not the final decision maker on applications, they argued that they couldn't have been sued for the screening agent's bias. Using this, Workday AI called to dismiss the case entirely, and the judge agreed with them. But they still allowed Mobley to amend the complaint, and that is exactly what they did. They sued Workday as an employment agency, although an indirect one this time, with the same suit of discrimination. They also added the Fair Employment and Housing Act, FEHA, of California, which added a disability discrimination law. And since the FEHA includes third parties and software companies as employment agency as well, it weakens Workday's argument of saying that they couldn't be held accountable just because they weren't an employment agency. Across the next few months, the lawyers argued back and forth constantly. Mobley amended their complaint to ask to represent other applicants facing the same AI bias, which the court did approve. And that's as far as this case has gone. Mobley had all the evidence that the AI was biased against people over 40 and applicants with disabilities. But because Workday wasn't the direct employer, the existing employment laws weren't strong enough to hold the AI accountable. In this day and age, old laws are having quite a lot of trouble keeping up with the illegalities that come from AI. Now, let's move on from AI discrimination, because while it is a large problem with AI and employment rights, there's a lot more. And if you have applied to a job or will be applying to a job in the future, you should definitely look out for this. So, to begin, let me ask you another question. If a job application requires you to submit all of your personal data, such as your social media posts, internet activity, and location data, would you apply? I wouldn't. But what happens when that choice isn't up to us? Now, you may be thinking, how is that possible? I'm in America and we have rights. How could I not have a choice? I just said no. Well, as the saying goes, ignorance is a bliss. You can't fight against something that you can't see or understand. And that is the exact trait that AI exploits, as has been the trend throughout these cases. But this time, the situation is a bit different. AI isn't being biased or discriminating with jobs. It's just invading the privacy of its applicants. Evidence number 3. Chrysler v. Eightfold AI, 2025. In this case, our plaintiffs, Aaron Chrysler and Shruti Bhamek, who are two very experienced professionals, each with over a decade of experience, applied for jobs at Microsoft and PayPal. but were given quick rejections. Now, I don't know about you, but I don't think you'd be able to go through job applications that quickly and release results. Turns out they were auto-rejected by Eightfold's AI agent, which would screen and rank them from 0 to 5 based on requirements such as attitude, behavior, and intelligence. That seems pretty normal, right? But they rate these based on, drumroll please, your social media, personal life, and other sites with your personal data. They sued as a class action under the FCRA, which was passed in 1970. The FCRA, whose full form is the Fair Credit Reporting Act, was meant to protect consumer privacy and increase efficiency, and it has been used in many other cases to create a few precedents, including one that says people should be aware of any information that is given to their employer and is used to determine their status or value. The Federal Trade Commission and the Consumer Financial Protection Bureau both confirmed that the FCRA covers a case like this, and these are the two agencies that enforce the FCRA. So, if there was any question that the FCRA can cover a case like this, they were the ones that would decide. And in 1996, Congress even made an amendment to the FCRA to show the importance of job privacy rights, which is why they added a requirement that companies need to tell applicants that they will be using information from their consumer report or another source. Actually, they went even further and said that if job applicants don't have a chance to review and correct the information in a consumer report, the company can't deny them employment just solely based off of the report. In this case, though, Aaron and Shruti were not notified of this at all, and they were, in fact, denied just because of the report Eightfold AI made of them. And they weren't even allowed to review it, so they didn't even get a chance to ask why they were rejected. And as I mentioned before, both of them had decades of experience in their fields. Since this is a class action lawsuit, there are putative or assumed plaintiffs. This simply means that anyone who was rejected in the same manner from companies that use Eightfold AI screening system were eligible to sue alongside this suit. But, of course, Eightfold AI did not follow that, which is the entire basis of this lawsuit. Since this lawsuit is fairly new, there has been very little progress towards a verdict. Eightfold AI has filed a motion to dismiss, but the plaintiffs haven't refuted it yet. The next hearing will be in August of this year, so I will definitely keep you guys updated when there's more information. This case is the evidence of how AI has spread so far that people can't even see its actual scope. AI is analyzing us in ways we can never imagine, hiding in plain sight, just as Eightfold AI was in here. Alright, so let's condense all of this information, shall we? AI is not perfect, but it is being treated as such. AI takes data from humans, and humans, whether we like to admit it or not, have bias. And sometimes people just unknowingly have preferences. You can be biased towards a particular personality or characteristic. This is all reflected in AI agents, making them biased towards certain things and characteristics, which causes them to reject people who are fully qualified. Now, a solution would be limiting the data AI gets, but that also puts a glass ceiling on its intelligence and autonomy. Or you could just limit AI in the workforce. But until a proper solution comes up, who will take the blame for an AI's mistake? Someone has to take responsibility, right? Well, the problem here is that there is no precedence. AI is fairly new, and our legal system hasn't had a chance to create laws just to regulate AI's mistakes. There are no laws that can help you decide who takes the fall for AI, or what information an AI can use to judge an applicant. In all these cases, you can notice attorneys trying to use old laws dating back to the mid and early 1900s. This is why AI cases get so complicated. There are so many holes in these old laws. And I'm not saying that old laws can be applied anymore, or that they're completely archaic. They are useful, but they were never meant to regulate or handle AI. So there will always be cases with AI where even the courts don't know what to do. And this problem gets worse when people don't even know where AI is getting its information from. This gap of knowledge among people about what AI can actually do is why AI is running so rampant. AI will pass us. It's not an if anymore. The only way for humans to prevent it from controlling their livelihood is through rules and regulations. So do this. Look at the current number of AI employment problems and look at the number of new laws, not the ones from the 1900s that I just used, are brought up to deal with those problems. I doubt you'll find many, if any at all. But now you have one more thing to put you ahead in the job market. You know how AI works with employment and what you can do if it gets in your way. In the meantime, as AI continuously grows, so will a justice system, and you can help it. This country has a lot of ways for a direct democracy to rule. One being the INR, or Initiative and Referendum. You can get your representative to propose and change laws about AI, but you can only do this if you know about it. And that's why I'm here, to break down the knowledge gap between what people think AI is doing in the world versus what it's actually doing. For more information on what's happening in your own backyard, podcast updates, and term lists for any legal terms that I use, check out at Legal Called Sanity on Instagram or check out my LinkedIn. And if you'd like to help further this podcast and prevent more legal blindness, as well as suggest topics for me to cover, please fill out the form linked in the description.